is Laura Hammond, and I'm Director of Content here at PracticeLink. And joining me today is Bruce Armon, who's a partner in the law firm of Saul Ewing and chair of the healthcare group, and a frequent contributor to PracticeLink magazine. Welcome, Bruce.
Hi, Laura.
So today we're going to be talking about Stark Law. Now, the Stark Law is a federal healthcare statute that governs both clinicians and healthcare lawyers. Bruce, can you outline the goal of the Stark Law for us in 30 seconds or less?
I will do my best. It's actually a very complicated statute, so we'll try and boil it down to its most essential elements. It's a statute that was passed back originally in 1998. It's been amended several times since then. There's a whole body of regulations to talk about the Stark Law. And under the Stark Law, the most basic issue in it prohibits physicians from making referrals for what's called designated health services that are payable by Medicare to an entity in which the physician or an immediate family member of that physician has a financial interest. And a financial interest can be things like ownership, investment, or compensation. So very broad in its potential scope.
So it sounds like an anti-kickback focus. Is that correct?
In some respects, it has the same focus as the federal anti-kickback statute in terms of stopping fraudulent activities or potentially fraudulent activities. The focus of the Stark Law, it's a separate statute from the anti-kickback statute, and is actually a little narrower in some respects, but has much broader ramifications in other respects, given the nature of financial relationships and physicians and family members.
So what is the most important thing for a physician to know about the Stark Law?
Sure. A couple of, I think, important takeaways. One, for any physician, whether they're an owner of a practice, whether in a private practice, whether they're employed by a governmental entity or a hospital system, they should follow where the flow of dollars are going. Understanding where the flow of dollars are going can help better ensure that you're participating in a compliant medical practice arrangement. So understanding where the dollars are going, understanding where the relationships are between the parties, and making sure that you're not doing something that you don't think is medically appropriate or medically necessary because of the financial relationships that might be at play.
And so there's a physician recruitment component to this somewhere. Can you explain a little bit about the tie-in between physician recruitment and Stark?
Absolutely. So one of the important things about the Stark statute, as broad as I said it was at the beginning in terms of defining the relationships that a physician or his or her immediate family member might have, what's called designated health services, one of the important elements of the Stark statute is that it creates exceptions, something that might otherwise be prohibited under the Stark Law. If we can fit the business arrangement into one of those exceptions, it's going to be deemed okay. One of those exceptions is relating to physician recruitment. There's a series of different steps that both the physician and the hospital that's looking to recruit the physician and the private practice that may be involved as well that need to follow to make sure that the arrangement works appropriately. And again, from the government's perspective, their interest is making sure that the federal healthcare dollars, Medicare, are being spent wisely and appropriately in their judgment.
So when it comes to physician recruitment, who needs to be the party that is most in tune with the Stark Law? Is it the recruiter side or the physician side?
I'm actually going to say it's both sides, because to be an effective recruiter, the recruiter needs to understand that this law exists. They need to understand where the potential pitfalls are of the statute, and they need to be able to explain to their client, the hospital or the employer, how best to make things work. And from the physician perspective on the other side, they need to make sure that the business arrangement works for them well, that it's compliant with all federal fraud and abuse laws and state fraud and abuse laws as well, including the Stark statute, and then making sure that the contracts actually work together to get the desired outcome for everyone.
So if something doesn't quite smell right for the physician, what are some steps that they should take?
Sure, a couple of things. The first basic thing I would say is follow your gut. If the arrangement doesn't seem right, there's probably something wrong with it. Don't be afraid to ask questions as you're going through the process, whether it's to your own attorney, to the hospital's attorney, or to the private practice's attorney, and certainly to the recruiter as well, to make sure they understand that you as the physician understand the importance of compliance with fraud and abuse laws, and then the importance of making sure that you're entering into a proper business arrangement.
Well, thank you so much, Bruce, for explaining the Stark Law to us, and thanks again for contributing to PracticeLink magazine. And anytime that you have questions looking for career resources, please go ahead and join us at PracticeLink.com.